So, the Department of Justice through Attorney General Bondi, 25 jurisdictions, and now numerous 2A groups have joined the battle against statewide concealed carry prohibitions, and these types of regulations are presently before the Supreme Court. Let's examine what is occurring. Now, really briefly before we dive into this video, if you want to back the channel for free, please think about subscribing to the channel. That assists the channel to expand. Just also verify to ensure YouTube is not unsubscribed to you because they adore doing that. And then simply leave a constructive comment down below because that helps to inform the algorithm that you value this type of 2A content and it should distribute to more viewers. As I mentioned in the introduction, in this video, I have an update for everyone in regions like New York, California, Hawaii, and others who are currently confronting attempts to prohibit concealed carry within those jurisdictions. You might remember that recently the Ninth Circuit delivered a decision on multiple concealed carry laws, which were enacted in direct response to what the Supreme Court stated in their Bruen ruling. One of those was the California SB 2 case, and then the other one was Hawaii's concealed carry restriction laws that they passed in direct response to Bruen. The lawsuit that's currently seeking Supreme Court intervention is the Hawaii Wilford versus Lopez matter, and this challenge centers around a preliminary injunction and the Ninth Circuit determining that states and their catch-all public property carry prohibitions are indeed allowable under the Second Amendment, and that Bruen does not alter that outcome. Recently, to the astonishment of many, the DOJ and AG Bondi have stepped forward in support of this challenge against Hawaii's carry prohibition. They recently submitted an amicus brief to the Supreme Court, contending that it is finally time for the Supreme Court to examine these carry bans that were enacted after Bruen, and to halt this lower court resistance. There was also a reference in that brief that they believe it's time for Supreme Court to address additional issues like rifle restrictions and magazine limitations that have been implemented in various states. This endeavor has now been joined by 25 jurisdictions and numerous Second Amendment organizations who are also calling for the Supreme Court to stop the active defiance that is happening currently at multiple levels. This regulation, like others, attempted to add more limitations to concealed carry and establish a default rule where individuals can carry firearms on private property only if the proprietor of that property provides explicit permission to those individuals to do so. In Hawaii, that authorization can come from displaying signs or from the property owner telling you verbally that you can conceal carry at that site. However, that doesn't really function like that because when is a property owner going to tell every single person that enters their location that they can conceal carry? Prior to Bruen, Hawaii's statutes operated as may issue, but essentially still no one even in the territory of Hawaii could actually carry under the may issue framework. In 2018, in fact, the Ninth Circuit observed that Hawaii had granted only 4 concealed carry licenses to private citizens in the past 18 years, and that one county had not issued a single carry license ever. However, in Bruen, the Supreme Court held that the Second Amendment guarantees a general right to public carry weapons for self-defense, and that may issue licensing systems for carrying handguns, like Hawaii's pre-Bruen regime, violated that right. Hawaii, in response, passed Act 52, a measure that overhauled the state's concealed carry laws. But through that new legislation, they created a hyper-restrictive system that was just as problematic and if maybe even worse than the one that existed prior to Bruen. Because of this, plaintiffs along with 2A organizations sued the jurisdiction to invalidate that new law. On review, a district court issued a temporary restraining order, also known as a TRO, which was later then transformed to a preliminary injunction. In that decision, the district court blocked the private property rule as likely a violation of the Second Amendment and inconsistent with what the Supreme Court declared in Bruen. This litigation then made its way to the Ninth Circuit along with the California carry ban case, which was a challenge to SB 2, and on review the Ninth Circuit upheld the catch-all property ban and reversed the injunction issued by the district court in Hawaii. The Ninth Circuit depended on older restrictions on hunting on private property to support this statewide carry ban that was in place in Hawaii. After that, the plaintiffs requested for the Ninth Circuit en banc panel to review this case, but that was rejected. Now, in that denial, there were dissents from multiple judges. In that dissent, they argued that the private property default rule effectively nullifies the Second Amendment rights of Hawaiians and has no foundation in the historical record. Now, this troublesome law and the troublesome Ninth Circuit ruling has made its way to the Supreme Court on an emergency basis, and the plaintiffs are asking for the Supreme Court to intervene on an interlocutory emergency basis and overturn what the Ninth Circuit said. Now, this case theoretically had a slim chance of getting Supreme Court review since it was still in an interlocutory preliminary injunction phase, and the Supreme Court categorically has denied many of those types of 2A cases. Typically, the Supreme Court desires final merits cases when it comes to the 2A legal issues. When it comes to other legal issues, they've accepted other legal cases at the interlocutory posture, but they've avoided all the 2A cases at that stage of litigation. However, now circumstances may change. The United States, through the AG Bondi and the DOJ, have stepped forward in support of the plaintiffs in this lawsuit against the territory of Hawaii and that concealed carry prohibition. Now, even better, you have the Trump administration that was joined by 25 jurisdictions, and now also numerous 2A organizations who are calling for the Supreme Court to finally take up this type of case, take action, and essentially correct what is happening at the lower court levels, and what's happening with some of the states directly defying Bruen. Now, in the recent amicus brief filed by the federal government, they stated that the near-complete prohibition is flatly inconsistent with Bruen and the long history underlying it. Bruen recognized that an ordinary law-abiding citizen has a general right to publicly carry arms for self-defense. Just as states may not limit that right to those who show a special need for self-defense, states may not limit that right to those who aimlessly wander the streets. Again, one of the fascinating things with that brief filed by the federal government and the Trump administration is they're saying it's time for the Supreme Court to step in on this matter even at the preliminary injunction stage. Now, these arguments are echoed in briefs also filed by 25 jurisdictions, and then also Second Amendment organizations who have jumped in to file amicus briefs in support of invalidating the Hawaii carry ban. In the brief of the 25 jurisdictions, they argued that Bruen reassured law-abiding gun owners that the Second Amendment was no longer a second-class right, but lower courts have largely failed to follow through on that pledge, resorting to manipulative en banc practices, historical interpretations of covered arms, and improperly calibrating the level of generality for Bruen's inquiry. These incursions on citizens' public carry rights will continue to grow unless the court intervenes. They went on to state that each of these pushes chips away at the scope of citizens' Second Amendment rights, and if unchecked by this court, Bruen's reassurance will be little more than an empty promise. Now, like I mentioned, multiple organizations have also jumped in, and they're echoing the same type of concerns, saying that the Supreme Court, if they don't get involved, essentially the Bruen analysis means next to nothing. They assert that if this court denies certiorari, there will be no meaningful right to carry in Hawaii for at least 7 years while the litigation proceeds. They go on to state that the Ninth Circuit's animosity towards the Second Amendment is well documented, having recorded an undefeated 50-year-old record of upholding gun laws before Bruen. Bruen changed nothing for the Ninth Circuit, and the Woolford ruling is not even the most recent example of the court giving a judicial middle finger to this court. So brazen has the Ninth Circuit's defiance become that even when the Woolford panel disgracefully relied on a racist law to justify Hawaii's law, the Ninth Circuit refused to correct it, denying en banc review over the dissent of 8 judges. Unfortunately, the Ninth Circuit has been encouraged by this court's reluctance to take Second Amendment cases in an interlocutory posture, but if there was ever a perfect case in which to make an exception to this court's preference of not deciding interlocutory matters, it would be this one. So here you have the federal government, the Trump administration, 25 jurisdictions, and multiple organizations saying that this is the case that the Supreme Court needs to step in on an interlocutory posture, because all the lower courts and all these states understand that there has been inactivity by the Supreme Court after Bruen. And if they go unchecked, nothing will really change, and essentially Bruen becomes an empty promise and really has no teeth. Currently, Hawaii's response brief is due on June 4th, and then there will be some final reply briefs from the petitioners. But with the DOJ's brief, the 25 jurisdictions brief, and now all these multiple 2A organizations. There is potentially a strong possibility Supreme Court would grant review to this case, even though it's an interlocutory posture, because Bruen was very clear that May-issue regimes were impermissible and that states needed to start actually issuing permits, and they needed to do it in a way that aligned with the Second Amendment. But you have a lot of these states that said, no, we're not going to do that. We're going to pass even more hyper-restrictive statutes. We're going to essentially maybe issue permits, but even if we do issue permits, which a lot of states aren't doing that, but even if they do issue permits, we're going to make the permit essentially worthless because you can't carry anywhere lawfully. So the hope is that the conservatives on the Supreme Court now have a strong signal from the administration, from majority of the jurisdictions, and from the 2A advocates at large that it is time to support striking down these concealed prohibitions and upholding Bruen and giving Bruen more teeth by striking down these types of laws and lower court defiance. So again, a lot is developing in this case, and it seems like there are some good indicators coming out to push the Supreme Court to step in on an emergency basis, and we'll see how the territory of Hawaii responds to all of this in the response brief. So as we get more information as this develops, I'll let you guys know, but as always, thank you all for watching. Don't forget to like, comment, and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.